In this video, we will be discussing Lecture 4, which is about the Declaration of Independence and Te Tiriti o Waitangi, the Treaty of Waitangi. This lecture covers the Flag of 1834, the Declaration of Independence 1835, a brief discussion on treaties, the Treaty of Waitangi 1840, the difference between Maori and British understandings, and finally we'll touch on what this means for contemporary New Zealand. The flag of the United Tribes of New Zealand symbolised a friendship of the tribes with Britain, and in turn an acknowledgement by Britain of the United Tribes of New Zealand. The flag was significant in trade, but was given a somewhat mixed reception. Despite this, it was significant to Maori, as the creation of the flag led them to believe that the mana of New Zealand, which was closely associated with the mana of chiefs, had been recognised by the British Crown. We will now move on to consider the Declaration of Independence 1835. There is a Maori version of the Declaration and an English version, and one is understood to be a translation of the other. There are 4 parts to the Declaration. The first declares independence. The second vests sovereign powers in chiefs, that there is no legislative authority or function of government except under their laws. The third is an agreement to meet regularly in Congress to make laws, and the fourth is a thanks to King William for acknowledging the flag made the year prior, and a request for protection from challenges to their independence. Overall, the Declaration of Independence was the British Crown recognising the sovereignty of Maori, and Maori as a people declaring their sovereignty. Remember that sovereignty is the undivided power to make laws and enforce laws through sanctioned physical powers. It is important to note the terminology used in the Declaration. In Article 1 and 4, independence is referred to as rangatiratanga. An independent state is referred to as whenua rangatira. In Article 2, sovereign power is referred to as kingitanga, and authority is referred to as mana. In Article 2 and 3, hereditary chief is referred to as tino rangatira, and in Article 2, function of government is referred to as kawanatanga. Before looking at the Treaty of Waitangi, we'll have a quick look at treaties as legal agreements. Treaty is the name for a legally binding agreement in international law. There is the assumption that both parties are sovereign nations that come together to agree about something. If there is ambiguity, for example, if we do not understand the exact terms in the contract, or the agreement is missing altogether, we look at contemporaneous documents, which are documents made at roughly the same time by the same or similar parties, which is using the same language. If there is a mismatch of meanings of a treaty, it generally becomes null and void. However, in the making of a treaty, the goodwill of both parties is assumed, and it is assumed that each have the best intentions. Therefore, in general, a compromise based on common ground will be identified. There were 9 official English versions of the treaty circulating. There is now one document deemed the official English Treaty of Waitangi, but unlike the Declaration, the English versions are not translations of the Maori versions. They are written separately. There are disputes over translations, and we will now go through each article and summarise what each version means and the disputes between them. In Article 1 in the English text, tribes cede absolutely their sovereignty to the Queen of England, while in the Maori text, the chiefs grant the Queen of England kawanatanga, governorship over others. As per the Declaration terminology which we covered earlier, kawanatanga means functions of government. This means that according to the Maori version, they were not ceding kingitanga, sovereign power, or rangatira, independence. In Article 2 in the English text, the Queen guarantees full, exclusive, and undisturbed possession of lands, estates, forests, fisheries, and other properties. The English version also establishes that the Queen has the exclusive right of preemption over land that Maori wish to sell, meaning that Maori must first offer the land to the Crown if they wish to sell. In the Maori text in Article 2, the Queen reaffirms the right of rangatira, chiefs, to exercise tino rangatiratanga, absolute chieftainship or independence over whenua, lands, kāinga, villages, and toanga katoa, all things treasured. Here the dispute lies between full, exclusive and undisturbed possession of land in the English version and tino rangatiratanga as per the Maori version. In Article 3 in the English text, Maori become British subjects, and in the Maori text the Queen will respect tikanga katoa rights ways of Maoris as she does those of the English. Article 4 was lost in translation and is considered to be an oral protocol in which the governor agrees to respect all faiths and the laws and customs of Maori. The Waitangi Tribunal wrote about Maori and British expectations of the treaty in the Murawhenua Land Report in 1997. Maori understandings were as follows. The Maori text is the primary text, though actually a chief's word and honour are more important than written text. There was an expectation that Maori would suffer no diminution of mana or rangatira. The Queen was to act as kaitiaki for Maori, and Maori were to protect the Queen's governor, that Maori and the Queen were in a partnership or alliance, that Maori and the governor would be of equal authority, and that the governor was to respect Maori social structure and deal with leaders. The British understanding, as per the report, was that the Queen's authority was absolute, and that radical title, which confers sovereignty but does not extinguish native land title automatically, was held by the Crown. The British thought that the Maori understood that Maori were only going to maintain possession of the land on authority of the Queen. Further, wastelands, which are lands unused or not in direct possession of Maori, were assumed by the British to belong to the Crown. The tribunal at the end of the Murawhenua Land Report commented that it is important to see the treaty, not in specific terms or details, but for what it mainly was, a statement of good intent of basic and necessary principles. Both parties were further apart than they thought they were when the treaty transactions were made, and are stuck at cross purposes. There are significant implications to accepting either version of the treaty. What is important for this course, particularly in exams and tests, is to consider bigger picture ideas. Given what we have discussed about the treaty, is the treaty a source of New Zealand law? And what place should the treaty have in the New Zealand legal system? Good luck studying. In the next video, we will discuss Parliament and the enactment of law.